G'day guys, welcome back. Today I'll be covering the IRAC for legal students. Now, the IRAC is a foundation for answering legal problems. However, there's often the issue of students not achieving the marks that they sought to achieve, so they're often only achieving passing grades, credits at best, and the issue lies within often the application. They're drafting as well, but more so it's often in the application or a component of IRAC where they are falling down. IRAC isn't explained terribly well at law school, so we're going to run through it today and explain how to do it properly. And if you apply this, you should see improvements in your grades. So the first thing we want to talk about is I for issue. So one thing to note about issues is we want to have a new heading for every issue or sub-issue. That's really important. We can never go wrong having more headings there for each of the issues or sub-issues we identify. One thing we need to do with the issue is we need to frame it as a issue statement in a form of a question, right? And the other thing we want to do too is we want to include the party or parties' names in the issue statement. That will come from the problem question. Next, we want to talk about the law. So the law is the second component. So with the law, we get very little marks here in terms of summarising or stating the law. This is because you are presumed to be a lawyer in training. Therefore, if you can't find the law, you shouldn't be studying to be a solicitor or a barrister. So with the law, we want to summarise it in our own words. What we don't want to do is we don't want to copy large slabs of the law. We want to interpret it in our own language, but then we footnote the relevant section or sections from the legislation that we're referring to. Also with the common law component, so we want to pick the leading case and even other supporting cases that will bolster our analysis and our argument. So you can get the leading cases typically from a secondary source such as a textbook on the substantive law subject that you're studying, or you can just do your own research through Osley, Lexis Plus or Westlaw, searching for keywords from the facts that you've been given. Okay. Now we want to get on to the important part, which is the application. Now, I recommend covering this in several components. So there's several parts to application. It's not just simply applying the law to the facts. So application part one, we want to look at for legislation in particular, we want to look at the rules of statutory interpretation. Now, you should have covered statutory interpretation as part of first year, and as part of that we want to look at things like the legislation's definitions section in the Act. We also want to look at the application of the Act's Interpretation Act, so whether we're talking at state or Commonwealth level. We also want to talk about other things like the common law approach, so that's the golden rule, so we're interpreting words in legislation in terms of their natural and ordinary meaning without confusion. And then we've got the purposive approach, which is looking at the overall objective of the Act. What is the Act trying to achieve, and applying that in our interpretation of the words we're looking in the legislation. Other thing is around those definitions too, just remember we have exhaustive and non-exhaustive definitions. So key indicators includes the words means or includes, which means there can be more than what they define in their definition. Second part for application, we want to explain why the legislation applies and do the facts of the matter meet the requirements outlined in the legislation itself? Application part 3, we want to talk about the leading case that we're using, or supporting cases. So we're looking at applying the common law cases which mirror the fact pattern that we're given in the scenario that we're trying to solve. Is the case that you're using analogous, or is it distinguished? So by that, analogous, I mean we're trying to find a case which closely mirrors the fact pattern, though sometimes we can't find a case which isn't a perfect match, and therefore it will be distinguished or different in some way, and we need to talk about that. I would also recommend here, when applying the common law to your problem, we need to look at explaining why. And now, this is where students fall down. They don't do a deep enough analysis. So you can use the 3 why technique. So you ask why again, and then why again. But often 2 whys is usually sufficient. So the key words we want to use here is because the plaintiff did this, because the defendant did that, because the common law test of negligence is not met here because of X, Y, Z. So we need to use language, we should be using the word because to explain why or why not the common law applies to the particular fact pattern that we've been given. Another thing we can do is you often find that better students or higher achieving students will also do deeper analysis on those leading cases that they're using by examining the majority and the minority judgments within the case. So they'll look at the differences in the ratio or the reasoning as to what did the majority and the minority said and what their differences was, and commenting on that as well in your answer. Rightio. And lastly, the focus of including your common law analysis is you should be focusing on the reason or reasons for the judgment or the ratio. We don't need to. We do provide some brief facts about the case, but you do not have to explain the whole case, because what we're looking for is the ratio or the test or the criteria that's used by the judges or judge to arrive at the decision. All right, application part 4. So we want to explain what remedies are available and explain which remedy, if there's more than one, which one would apply will be better. So remember, we have common law remedies like damages, but then we've also got equitable remedies such as injunctions, and they are different and they suit different circumstances, so we need to explain why. Okay, we have application part 5. We need to talk about now any exceptions or defences or excuses that would alter the final result. Application part 6. Now, this is often not done well by a lot of students, but we really need to be having you think like a lawyer. So we need to discuss arguments for and against your position applied thus far. It's important that you demonstrate both sides of the argument, not just the obvious answer, which you know will be correct, but you also need to think of the counter argument. Just like you would in court, you have to anticipate what your opponent may do in court on a hearing. So by not thinking about that and examining the weakness of your argument or counter argument, you are giving away marks. So that's something that you should pay particular attention to. And then lastly, part 7 of application, we explain which is the stronger argument. So just the logical argument that you've arrived at and why it is stronger than any weakness or counter arguments. Lastly, C for conclusion. So caution your conclusion with the words likely or unlikely, because there's no certainty until you go to court. And because we're at law school doing this, it's hypothetical anyway. So we always caution our answer or our conclusion or our final result with the language likely or unlikely. And you can go a little bit further if you want, and you can discuss which court the matter will be heard in, what is the standard of proof. So if it's a criminal matter, beyond reasonable doubt. If it's a civil matter, on the balance of probabilities. And we also discuss the applicable remedy that would apply, any exceptions, defences or excuses available. Okay, finally, last thing I wanted to say is just a breakdown of the marks for an IRAC application. So on average, these are just very rough numbers, but if you get all the issues identified, that will give you about 20%. Remember, summarising the law, get very little, so I would say, yeah, very low marks or 0% there. Application is everything. It is the most important bit that you need to focus on, and that's where your word count should be going into. So that's worth at least 60%. And then, yeah, if you arrive at the right conclusion or result or outcome, that will also give you 20%. So you can see how roughly people can still achieve a pass with a very poor attempt at the application. And those students who do the application well as well as the other components are getting the distinctions and high distinctions in their studies. Hopefully that's been of assistance. Please like and subscribe, and I'll see you in the next one.